After leaving the White House, Bill Clinton kept 79 audio tapes in his sock drawer. When he was sued for them, he won the case. Judge Amy Berman Jackson's decision states, under the statutory scheme established by the Presidential Records Act, the decision to segregate personal materials from presidential records is made by the president during the president's term and in the president's sole discretion.
And he's absolutely right, 1,000% right. There he is, Bill Clinton. And he made these tapes with some historian, and it was highly litigated, and it included our next guest, Michael Bekesha, senior attorney for Judicial Watch. He wrote about this in yesterday's Wall Street Journal. Great piece. I hear about this Sox case all the time. I don't quite get it. Michael, how are you?
I'm good. Thanks for having me tonight.
Many thanks. Listen, the president was right there, and you were the guy. Can you break this down for us, if you don't mind?
Absolutely. I mean, first off, I was the guy to lose. So, you know, it's a little bit painful to hear President Trump talking about a case I lost.
But it's a good thing you lost.
Apparently. So, you know, what we had was we learned that President Trump, while he was in office, he was recording tapes with this historian. And on the tapes were conversations President Clinton had with members of Congress, with foreign leaders, talking about policy, talking about potential military activity. So all the sorts of things that would be classified information had the tapes been in the possession of the White House. But instead, President Clinton kept these tapes in his sock drawer. And when Judicial Watch learned about this, we asked for the tapes from archives. Archives told us, oh, those are personal records. They're not presidential records. We didn't believe them, and so what did we do? We sued. And when we got into court, when the archives was represented by the Justice Department, they changed their tune. No longer did they say they were personal records. They said, no matter what they were, the President of the United States made a decision that they were personal records. He took those records. Now there's nothing that the archives or the federal government can do about it. And the court in 2012 agreed. Judge Jackson stated, she ruled in a nice long opinion, that it's in the sole discretion of the President of the United States to decide what records are personal, what records are presidential. When stuff is placed in boxes and deemed or categorized or classified as personal and taken with the president when he leaves office, there's no duty or obligation or even any mechanism for the federal government to go and get those records if they think those records were that they weren't personal records, that they were presidential records.
I get it. No, I'm sorry. I get it. It totally makes sense. But let me ask you something. How much of this do you think, in retrospect, is personality driven? You know, they have the same laws, the same set of facts, or similar set of facts. I feel like they wanted to protect Bill Clinton, you know what I mean? And they want to hurt Donald Trump. And sometimes this comes from a personal, you know, visceral point of view. And then the judges, the lawyers, they make it work around that driving force, though. Does that make sense?
It does make sense. I mean, I believe this is all politics, because otherwise, why would the Justice Department and why would the Justice Department change their tune, right? Only 10 years ago, they were arguing they couldn't do anything about records a president took with him when he left office. Now that they're saying, oh, not only can we look forever for potential records, but we can forcibly take them by a search warrant. And so something has changed, and the only thing that has changed is whose records they're looking to get.
All right. So they are not talking about the Presidential Records Act, though, in this indictment. It's the Espionage Act. And they did that on purpose because they know what you know, correct?
Absolutely. I mean, but the indictment starts reading like it's going to be about the Presidential Records Act. Paragraph 2 of the indictment talks about how Trump, during his time in office, placed documents in boxes. And then paragraph 4 talks about when he left the White House, how he took those documents he placed in boxes and took them with him. So that sounds like the Presidential Records Act, but it's surprisingly absent from anywhere in the indictment. In there is the Espionage Act. And under the Espionage Act, the question is whether or not President Trump is authorized to have the records that he still has. And there's no dispute that when he was president of the United States, he was authorized to do whatever he wanted with those documents. So with the Espionage Act combined with the Presidential Records Act, President Trump, while he was president, could have made a decision that he was going to keep these records when he left office. And he took the records with him, and that's where the Justice Department is today.
By the way, when was this lawsuit filed by you?
It was, I think, 2010 with the court ruling in 2012.
Okay, yeah, because he's all right, that makes sense. I was like, was this in the 90s when Clinton was president? You couldn't have been anyway, we appreciate it so much. Michael Bekesha from Judicial Watch, please, you guys are the best. Keep it up. Thank you, and we'll be right back.